Hello, this is Don Swanson, and I'm here today with us is Professor Ronald Mann from Columbia Law School. We're going to be talking today about a book that he published back in 2017. It's a fabulous book that should be in every bankruptcy professional's library. It's called Bankruptcy and the U.S. Supreme Court. And Professor Mann is particularly well qualified to write and speak on this subject because of his experiences with that court, starting with clerkship with Justice Powell at the Supreme Court, and then arguing cases before that court as Assistant Solicitor General. And so welcome, Professor Mann.
Good morning.
Let's start with this question. Would you just talk about some of the themes that run through your bankruptcy and the U.S. Supreme Court book?
Okay, well, the book really has a easy, low-hanging fruit kind of premise and then a harder explanation for why that is true. The easy premise that I think the book pretty readily establishes is that in closed cases where, in the view of the Supreme Court, the statute isn't all that clear, the Supreme Court has systematically interpreted the bankruptcy code narrowly. And what I mean by narrowly is interpreted it to limit the power of the bankruptcy judge to interfere with pre-existing rights that creditors would have outside the bankruptcy system. And so that's what a lot of the book is about, documenting that. The harder part of the book, which is, I think, much more debatable than I offer, is really like my personal opinion, and I don't think you can really prove it, but the book offers some evidence to support it, is why that's happened. And my theory about why that's happened is that it's because when Congress adopted the bankruptcy code, they didn't create any type of agency to support it. So for the Securities Act and the Securities and Exchange Act, there's a Securities and Exchange Commission that's up there in the Supreme Court every year explaining to them why these statutes are so important. Now, they're self-interested and biased, but they're also expert. And so when they tell the Supreme Court it's very important to the securities markets that the Securities Act be interpreted broadly, that has some weight. But in the bankruptcy context, there's no one that ever tells the Supreme Court on behalf of the federal government why this is so important. And in fact, historically, when the Solicitor General appears in these cases, most of the time they appear as a creditor. The United States is one of the largest creditors in the United States, and they appear as a creditor telling the Supreme Court that it's really important that you limit power of the bankruptcy code to interfere with creditors because we're a creditor. And so that's a more contestable premise. So the big part of the book, though, is just talking about the way the Supreme Court decides these close cases. And so what I did is I went back, and for all the cases that are old enough that you can get the justices' papers, I got all the internal papers that reflect how the justices decided these cases. And so the cases are relatively old because you typically can't get the justices' papers till many years after they've died. So for example, the time I was writing the book, Justice Brennan's papers were just slowly becoming available. So I had all of Justice Powell's papers, some of Justice Brennan's papers, all of Justice Marshall's papers, Justice Blackmun's papers, but no papers, for example, Justice Scalia, much less people are still on the court now. So I was limited to cases that were decided before about 2000 for these case studies. But those case studies, if you like bankruptcy law, some of them were pretty interesting. So the first close case that the Supreme Court decided, Bill Disco, you go look at these papers and you see this draft opinion that Chief Justice Rehnquist wrote, and I would have never have known that Justice Rehnquist was a big bankruptcy preferring justice, but he wrote this really strong opinion about how important this new bankruptcy code is, and this bankruptcy court really needs to be able to turn off these collective bargaining agreements. These companies will never be reorganized. Had some really strong language in it. Well, the reason I never had known about that is because if you go read the opinion in U.S. reports, none of that language is in there. And what happened is Justice Stevens wouldn't join the opinion. And they went back and forth for months. And he couldn't persuade Justice Stevens to join it. And so eventually he just had to take all that stuff out. And so the opinion that's written is really ambiguous and difficult to understand, but it's because it's completely a watered down compromise. And in the end, it was one of these things where you'll get my vote if you take in every single thing I don't like and put in some really vague things that I do like. And if you don't, then, I'll go vote with the other side. And so Justice Rehnquist, being a kind of person that likes to win rather than lose, eventually had to give in. And so the opinion, to this day is very vague. And to this day, we have a lot of problems with what happens with the collective bargaining agreements in bankruptcy, because the Supreme Court really didn't say much in that case about what happens other than that they don't pass through unaffected. But what happened the next year is even more interesting, and it's, I feel good and bad about it. I feel good about it because it shows how much more skillful Justice Powell is than some of the other justices at accomplishing his goals. So what happened the next year is, same thing happens. This case comes to the Supreme Court in Mid-Atlantic, and this case has to do with environmental contamination. You have this really colorful environmental criminal who was doing things like he would pick up your toxic waste and he could get rid of it really cheaply, because what he would do is he would just pump it into an empty coal mine, or he would pump it into the East River. It's super cheap to dispose of waste if you don't safely package it, but just pour it in the East River. And so he was very successful. After he was in jail, his companies were in bankruptcy, and the question was whether their assets would be used to clean up this environmental contamination or whether they would go to the creditors. And so this case gets assigned to Justice Rehnquist, and he writes his opinion saying, well, the creditors should lose because the bankruptcy court should be able to order this environmental stuff to be cleaned up. And Justice Powell is in dissent, and he only has 4 votes, so he's going to lose his case. But see, what Justice Powell did is he worked really hard in his opinion, and he circulated his dissenting opinion the day after Rehnquist circulated his majority opinion. And he worked really hard and lobbied Justice Stevens. Well, this time, Justice Stevens switched his vote. So the case originally, the creditors were supposed to lose, but Justice Powell lobbied Justice Stevens, got him to switch his vote, and so the case comes out the other way because he turned the court. Well, of course, I like to see Justice Powell win one because I worked for him the year after this. But you put on your hat as an academic, the logic of why he did that has been really crucial to the way the Supreme Court has interpreted the bankruptcy code since then. Because he articulated this principle that sounds good if you just say it as a jurisprudential principle, which is, well, if you see some language in the Bankruptcy Act of 1898 and some language in the Bankruptcy Code, and if they're pretty similar, we should assume that the Bankruptcy Code was not supposed to change rules under the old act. Now, he didn't have any cases to support that. He just asserted it and got 5 people to sign the opinion. So that's what it takes. 5 people sign the opinion. He asserts it. Doesn't matter that no one has ever said that before. Even though he says people said that before, he just kind of makes it up. And it becomes this principle that's enshrined in the Supreme Court's bankruptcy jurisprudence from the earliest days, which is we should assume that Congress didn't really mean to change very much when they adopted the bankruptcy code. Now, historically, that's just not right, because historically what happened is that Congress decided the Bankruptcy Act was really badly broken because businesses were not reorganizing where there was a lot of value left on the table. And so they had a commission, and this is not the kind of thing you can imagine in the 21st century, but it was a commission of bankruptcy judges, scholars, and practitioners, and they had hearings for about 10 years, and they produced this long report, and people in both parties agreed it was a good idea. So then the statute was adopted with large votes from both sides of the aisle and no real partisan divide at all. The only dispute in the statute really came from the judicial branch, which is that the proposal of the commission was that there would have been a bankruptcy law commission in the executive branch that would have administered, really low-level consumer cases and things like this. And the judges were going to be Article 3 judges. Well, the Chief Justice of the United States didn't want a lot of new Article 3 judges because he thought this would dilute prestige of having Article 3 judges. And so he pressed really hard for them not to do that. And so Congress didn't do that. They had these judges that were much like the old referees. But then, of course, the Supreme Court said that was unconstitutional. So then there's this complicated workaround. But none of this had anything to do with the authority of the bankruptcy court, which Congress thought they needed a lot more authority, and there was a statute to give them a lot more authority. And then the Supreme Court said you write a statute to give them no more authority. And that's what has flowed through the cases. And these case studies in the book show how that presumption really has dominated the way the Supreme Court has decided the close cases down through the years. And that's the bulk of the work in the book.
Well, that is fascinating. So I've said a number of times, if you look back at some of the Supreme Court cases that come down, they just basically, for us practitioners, they screw up our world by saying that the bankruptcy court doesn't have authority to do things. So is that right, or is that looking at it wrong?
Well, no, I think that's the way you'd feel about it. I came to work on this project really because it reflected my personal experience. So when I was in Solicitor General's office, I argued some of these bankruptcy cases. And like the one that's easiest to talk about, because it's a big chapter in the book, is BFP versus Resolution Trust Corporation. And the question in this case is, what's the extent to which the bankruptcy code's fraudulent conveyance power allows it to invalidate a foreclosure sale that would be valid under state law? And so as a backdrop, as a bankruptcy law practitioner, you'll know that it's pretty hard to overturn a real estate foreclosure under state law. That just is a really hard thing to do. You can get the price reset, but to actually undo the sale and take the property back, that's a very hard thing to do under state law. But the bankruptcy code has this broad fraudulent conveyance provision under which the bankruptcy court claws back property that was transferred before the bankruptcy all the time. And it's not all that hard to do. In particular, you're supposed to be able to do it when the price that the creditor got for the property is not reasonably equivalent to the value of the property. And so the issue in BFP versus Resolution Trust Corporation, it's a classic Supreme Court case, is if you have a foreclosure sale and the price that you get the foreclosure sale isn't reasonably equivalent to the value of the property, can the judge go take the property back? And if it was done in some sale that wasn't a foreclosure sale, the case would of course be yes. So I'm arguing this case for the government, and the government's view is, well, we're the biggest creditor on the planet, and we're up there saying the Resolution Trust Corporation, which at the time just has all these assets from failed S&Ls, and the SBA, which is in the business of making bad loans, and they were really, really good at making bad loans, and the Farmers Home Administration and the FDIC. And so we're up there telling the Supreme Court there's just billions of dollars of bad loans. You really need to make it easy for us to keep this property which we foreclosed. It'd be really bad if you didn't let us do that. And so when they decide the case, Justice Scalia, the high priest of textual analysis, says, well, in my view, in determining what reasonably equivalent value is, the price is just totally irrelevant to what value is that they got for the sale. Okay, well, that's not what I would say about that is I must have done a good job arguing that case to get him to say that, because that's not the first thing you would say if you thought about the text of the statute. And what I would encourage you not to do is to read the dissent by Justice Souter, because I think an objective person, if they read Justice Souter's dissent, would say, well, Justice Souter really had a much better argument in this case about the text than Justice Scalia. And so I prefer to think of it as it must have been a tremendous job of advocacy on my part to get him to say that. But it fits in with the theme of the book, because what he says is, well, text to this kind of text, that kind of text, but bankruptcy courts have never been able to overturn foreclosure sales for centuries. They've had foreclosure sales in bankruptcy courts and they couldn't overturn them, and we're not going to change now. So he's just saying, in the old days, bankruptcy courts shouldn't do it. I'm just not persuaded we should do it now. And the fact that the statute could be read to suggest that that's not going to get me to do it. But that's really the point of this book, is the fact that Congress wrote a statute suggesting bankruptcy courts can do lots of things they couldn't do. In the views of the justice, that's just not a good enough reason to do it. You have to really tell them. If you really tell them, they'll do it. And there are some of these cases where it's 9-0 because Congress really told them, but they have to tell them pretty clearly.
One of the things I note in your book is I believe you said something like the Supreme Court rarely references the phrase in the Constitution dealing with bankruptcy, that we're supposed to have a uniform bankruptcy law throughout the country. Am I right on that? And if so, what's that all about?
Yes, there's some chapters to talk about the Supreme Court's constitutional cases, and there's several constitutional areas where the bankruptcy uh, uh, code confronts other provisions of the Constitution. So, of course, there's the question of, do bankruptcy judges need to be Article 3 judges that are going to have the powers given under the bankruptcy code? And the Supreme Court has gone back and forth with exactly what can bankruptcy judges do, starting from from Northern Marathon Pipeline in the very early days to these cases they've had the last few years that Chief Justice Roberts has been writing in. And then there's this other topic of sovereign immunity, which they've had 3 or 4 cases about sovereign immunity, where the area question is, can a bankruptcy court go and claw property back from a state that has sovereign immunity? And that's been a big problem for the justices. What's the extent to which statutes adopted under the 14th Amendment can overcome the sovereign immunity of the states? And the Supreme Court has been pretty skeptical of the ability of Congress to do that under the 14th Amendment. Now, if you were just arguing these cases, the first thing that would come to mind is, well, if they adopt something under, let's say, Article 1, Section 8, Clause 3, the general welfare of the United States, okay. That's not enough to overcome sovereign immunity of the states. The Supreme Court said that, because just this general welfare, that's kind of vague. But there's a specific clause in the Constitution in Article 1, Section 8 that tells Congress they're supposed to be able to adopt bankruptcy statutes. And you would think if they're supposed to be able to adopt bankruptcy statutes, that ought at least to be relevant to deciding how those proceedings will be adjudicated. And you would think that'd be a serious question for constitutional analysis and deciding whether or not Congress gets to decide how these judges will be appointed, what their powers would be. Now, the very first one of these cases, Marathon Pipeline, this topic got discussed a fair amount of the oral argument, but it's never been a word of it mentioned in the cases until the very last one. And the very last one, which involved student loan debt in a Northern Community College, they did eventually mention it some, but it's very rarely thought of. And you would think that just constitutionality things in the bankruptcy code, it ought to be relevant that there's a specific clause authorizing, delegating to Congress the power to do this. And that's not been impressive to the justices, with one really rare example.
So what have you seen any trends since the time of your book? It was published in 2017. Since in that 3-4 year span, have you seen any trends that are?
I think it's mostly been going about the same way as it was under the book. I would say the most important bankruptcy case that didn't make it into the books, is too recent, is Jevick, which is the case about whether courts can have these structured dismissals in which you'll dismiss the bankruptcy, but you won't dismiss it and put things back in the box. You'll dismiss it and change some of the people's rights. And in Jevick, the Supreme Court said that, generally speaking, you can't have a structured dismissal that ignores the priority rules that you'd have in a bankruptcy plan. So in that case, they had a structured dismissal that was going to allow a recovery for some general unsecured creditors at a higher level than some priority creditors who are going to be completely wiped out. If there had been any type of plan or liquidation of bankruptcy, the general unsecured creditors could not have gotten anything until the administrative priority creditors were paid in full. And in this case, the priority creditors had a claim under the Warren Act for closure of a plant, which would have been a priority claim. And the secured creditors wanted to give some money to some general administrative creditors to get them to waive a lawsuit against them. And the Supreme Court said, well, you can't do that. See, that case follows this general trend you see in the Supreme Court cases, which is a really vigorous enforcement of the absolute priority rule. But that really vigorous enforcement of the absolute priority rule, and of course, I usually represent secured creditors, so I'm all for it, but vigorous enforcement of the absolute priority rule is the flip side of limiting the power of the bankruptcy court to do the things that the bankruptcy judge believes are appropriate. And this fits in with that trend, I would say, of the trend of the book. And it's probably the most important case, I think, that's not in the book. I mean, maybe there's one, but I think that's the one that's most interesting to me.
And have, in terms of new publication efforts, writing, studying, relating to the Supreme Court at all, have you got anything in the works?
Well, the last part of the book has some chapters where I look at the role that amicus filings play in these cases, and I collected all of the amicus briefs, and I went to look at where did the Supreme Court get the sources they use in these opinions, because I'm trying to figure out when the Supreme Court decides these cases, where do they get the information that they use to decide how the case should be decided? And they get some information from the parties, they get some information from the briefs of the amici, they get some information from their own experience, and they get some information from their research. And so I look at the sources that are in the opinions and try and see how many of the sources come from the briefs of the parties, how many of them are in amicus briefs, but not the briefs of the parties, and then how many did the justices go and find themselves. And I thought that was a fairly interesting exercise in the book. And so what I've done is I've extended that data collection to the decisions of the Supreme Court more broadly, so that I have this paper where I've taken all the cases from October term 2014 through October term 2019, so it's about 350 cases. And I collect all the briefs and I sort through the cases to see how often the amicus brief cited and what's the extent to which they provide citations in the opinions. And about 20% of the citations in the opinions are sources that are cited in amicus briefs, but not the briefs of the parties. So it's a fair number of sources, and there's quite a number of citations to amicus briefs. Most cases the Supreme Court decides have quite a number of sources uniquely provided by amici or citations from amicus briefs, and this paper kind of quantifies that. And to the extent it has a more specific pointed thesis, the thesis would be that briefs that are filed by for-profit entities, which trade associations like the Chamber of Commerce or the Business Software Alliance, or by businesses, Microsoft, Apple, people like that, those briefs empirically are significantly less likely to be cited and significantly less likely to provide sources than briefs that are filed by other groups. So briefs filed by groups like academics are more likely to produce citations than briefs filed by corporations or trade associations. And it's a little hard to figure out why, and I have some general ideas about that, but I sort of pointedly note that the briefs that are filed by the for-profit entities, those empirically are the ones that are most likely to have the most expensive counsel, the people that are experienced Supreme Court advocates, but they sort of aren't really getting what they're paying for, because those briefs, have less of a discernible effect, and maybe they have a effect that justices don't admit, but it's kind of surprising that you don't see sources from those people. You do see sources from academic briefs or historians' briefs and things like that more commonly. So that's what that paper's about. Very little about bankruptcy law in that.
Oh, that's fascinating. I really appreciate it. I know you have some limited time, and I really appreciate you being here today. By the way, Professor Mann's book, when this comes out on a publication in the blog, there will be a link, an Amazon link to his book there. So encourage everyone to go and get that. But thank you again.
All right. Be sure you buy the paperback. The hardback is really expensive.
Or Kindle.
Or Kindles. If it's on Kindle, I don't know if it is, but if it is, I'm sure it's much cheaper.
Well, thank you. Appreciate it very much.
Have a great day.